And to discuss several aspects of the data protection bill, I am joined by a stellar panel here on Tech Today. We have Nappinai, Advocate Supreme Court and founder Cyber Saathi. We also have Pranesh Prakash joining us, founder Anekaanta Advisory Services, and of course, Kanishk Gaur, technology expert and founder at the India Future Foundation. Guys, thanks so much for joining us on Tech Today. Ms. Nappinai, I'd like to start off by asking you about your thoughts on the long circuitous journey we've had with the data protection law. More importantly, the fact that within the course of this week, it has literally zoomed past both houses of parliament. In comparison to previous iterations of the bill, of which there have been many, are you pleased or displeased with the current data protection law?
I would say that, for something that took 6 years and 4 drafts and many, many consultations, the outcome was not exactly what we expected. So, to ask whether I'm pleased or displeased would be like, assuming law ever works in black and white, and it never does. We're always in the gray zone. So to the extent that we have a law itself, I'm definitely happy. To the extent that certain changes were made from the 2022 draft to ensure that, issues like the composition, the powers, the functions, and the other nitty-gritties in terms of the Data Protection Board have now been set out in the Parent Act. Whereas in the last draft, if you see, it was actually moved to the central government through delegated legislation. So this kind of arm's length dealing with the board is a good move. A lot of other moves in terms of modifying deemed consent, and then, bringing in legitimate use alternative and diluting the extremely open-ended illustration that the deemed consent option had are all good moves. But if you look at the negatives, unfortunately, I would say they far outweigh the positives.
Okay.
And here is my problem. The first and foremost, they say if you share voluntarily and publicly, then you're not protected under the Act. I believe that's a very myopic idea of what data protection laws are meant to be. And that's not how it's supposed to work. Whether you share voluntarily or not, and publicly or not, you're supposed to have certain rights, including, for instance, the right to be forgotten or right of erasure, right of correcting the data which may be wrongly recorded, etc. So to totally take away data that's shared publicly, I think is extremely dangerous and definitely does not protect user rights. If you look at the illustration, it is very strange. You would expect a data protection law to limit the kind of data that will be collected. Instead, the illustration goes on to say that an act may collect data which is not necessary for the service it's rendering, and still doesn't say such collection is illegal. It merely says you will then limit the use of that data for the purpose of the service. I really fail to understand this logic. If you're saying that the data is not necessary for rendering the service, then what is the purpose exactly that you believe a company is collecting the data for?
No, absolutely. Some very pertinent points made by Ms. Nappinai. I just want to come to Pranesh. Pranesh, we're going to obviously elaborate a little bit more about the Data Protection Board, because there's a lot of buzz about how that would operate as well. How can we really ensure independence and impartiality of such a organization? But if you look at the 2019 edition versus the bill's 2023 edition, and I really have to list each of them because this has been nearly a decade-long process, the provisions that really spooked the Googles and Facebooks of the world, especially when you talk about cross-border data flow restrictions and also the penalty cap in the previous rendition. Do you think that those are largely welcome modifications and amendments to the previous drafts, Pranesh?
I think there were problems with the previous draft as well, and there continue to be problems now. But overall, I think given that we have principles such as data minimization, purpose limitation, storage limitation, requirement for consent for most cases, legitimate use exceptions, or legitimate use as a ground for processing. And we have the basics of a data protection law here. I think to that extent, this is very welcome news. There are a number of concerns which I think fall broadly within 4 or more buckets. One, around the kinds of exemptions and potential exemptions. So there are potential exemptions for various kinds of governmental use, and where the government actually goes with this will be of much interest and potentially subject to court challenge as well. Data of non-Indians, and given that India is a big outsourcing hub, that's of concern as well. So outsourcing companies might not fall within the scope of this law to the large extent. And again, publicly available personal data that you made available publicly, as Ms. Nappinai said, that might be of concern as well. So that's one bucket. Another would be around the challenges this poses to freedom of expression and freedom of press. There are no exemptions for journalists in this law, and that will have to be adjudicated perhaps at a later date by the courts. This weakens the Right to Information Act in order to make privacy a stronger contender, and that is also potentially of concern. Third, there are concerns around privacy. So given that there's a different regime for people of different age, different regime for those who are below the age of 18, age verifications becomes a requirement. And that's something that globally there might be that might be a practice, but in India hasn't so far been a practice. And how companies go around verifying people's ages, whether they follow data minimization or do what many companies do right now, which is just ask you to upload various ID documents and so on. How we actually go about putting in place an infrastructure for age verification, which isn't overburdened, that's of great concern. And lastly, the problems of enforcement, which is, this is not an independent data protection board, and it is over centralized at the same time, where civil courts are kept out of the process. So there's no way that it's going to be able to deal with an entire country of 1.4 billion people and their data concerns through a single data protection board. So there are a lot of issues, but all in all, I think this is a great first step. We'll need to work on these things iteratively through the court, through the common law, and hopefully with amendments if needed in the future based on how it ends up working in practice.
Well, interesting, Pranesh. You did list out a bunch of concerns, but largely it is a welcome move. Something I do want to pinpoint from the plethora of things that you mentioned is this publicly available data point that you raised. And largely, when you look at what's happening in the world of technology, Pranesh, and for all of us, generative AI, a lot of emerging tech, which is the buzzword really this year. And if we're looking at a future-ready or a future-looking sort of legislation, then do you think this is a little bit of, well, a misstep and something that has really been missed in terms of looking at AI and talking about it in the wording of this particular law?
No. So specifically while looking at AI, I don't think this is a problem. Whatever concerns we have with data collection for AI, we should deal with separately, in my opinion. And
when you say separately, you'd say a separate legislation altogether, like an AI Act, so to speak.
In a separate legislation altogether, because at the end of the day, when people raise concerns around privacy and around copyright, when it comes to AI data collection, I think those are largely mistaken or misplaced concerns because of how generally we deal with copyright and privacy and data protection issues. It's just to say that you can't use it for specific purposes, but you can learn from publicly available data, even if it contains private information. You can learn from copyrighted data, and that's in fact what ends up happening with AI. It's not a matter of just storing this data. It's a matter of learning from that data. And I think people tend to conflate the two. And I think, which is why concerns around AI and data protection need further thinking, careful thinking. And you can't you shouldn't be overly restrictive of AI in the name of privacy, because you could end up doing a lot of harm as well.
Fair enough. Kanishk, I want to bring you in on this. One, I'd like to know if you share that view with Pranesh about the fact that a lot of emerging technologies haven't been mentioned, and also about publicly available data, and also the fact that when we look at this particular bill and we compare it to other legislations around the world, there's going to be a natural comparison, which is quite obvious with what the EU did with GDPR and the exemptions provided over there. I think there's nearly a dozen or more such exemptions. Over here, we have now 4 or 5 such exemptions. And there's one which is making the news in a big way, which is the exemptions given to startups as well. Kanishk, what are your views on the exemptions in India's data protection bill?
Thanks, Aayush, for bringing me in. See, startups will definitely need time to adapt. They are at a stage where they need to focus on growth. For them to hire a data protection officer, it's going to take time. For them to comply, they need. So the exemptions given to startups is a great move. However, when it comes to government organizations, there needs to be a structure which organizations you want to bring in under the law and which ones you want to give exemptions. The largest databases in India where personal identifiable information is collated is held by the government. There are bodies like Election Commission of India, Aadhaar, UIDI, GSTN, right? Now all of them have a lot of PII. If those are not covered under this law, then this law creates a huge risk, right? You're opening up a Pandora's box. And there are companies who are supporting these large databases because they don't do everything by themselves. So the implication of keeping them away also means the service providers who are working with them, keeping those out of it, right? So the implication could be huge, saying, okay, you are Airtel. If you are collating data for say UIDI, what kind of law will apply to you? Because you are holding their data center and the data center has PII. But since you've got UIDI out of it, would you as a supplier or a third party to a large government database be impacted by this exemption? Those are aspects which need to come out more clearly, right? Whereas the same company might be collating a lot of that data directly as well. So that needs to come out because these third-party service providers would work for both government and for enterprise. So that's something that needs better clarity. How are you going to define the exemptions for government bodies? That also plays a very, very important role. Under what garb are you doing that? Is it under the name of national security? You want to keep certain entities out of it, or primarily for secrecy, you want to keep some of them. So that definition needs to come out really well. It's ultimately up to the government, but just saying that we are enforcing it on the industry gives out a wrong message, saying that you're just trying to give a leeway to startups and the government sector. So that's an area where further clarification or explanation from the government would play a very, very important role.
Fair enough. And I think to a large extent, we've seen a bunch of Zoom sessions and press conferences from the ministers. We urge them to join us here on Tech Today and continue the conversation. Ms. Nappinai, I also want to understand from you, as someone who understands the law aspect of this on this particular panel, how do you view the fact that a lot of this conversation and narrative about the right to privacy as a fundamental right over the years developed maybe in 2017 with the Puttaswamy judgment, and the fact that there was a mention of informational privacy in that particular judgment, that doesn't seem to find any mention in this particular version of the legislation as well. Is that something that has been incorporated, you feel, those legal principles, or is that an alien concept to this current rendition of the data protection law?
No, certainly not. If the law is meant to implement the right to privacy, then it is meant to capture all the principles, the data principles.
Sure.
So if you look at even the law which was extant till a day back, that is 43A under the IT Act and the rules framed under that, it actually captured the 8 data principles, which was a kind of combination between the UK Data Protection Act of 1998 and the EU 1995 Directive on Data Protection. So when we look at the way the law has evolved now, and that is where my concern actually arises. We had a minimalist process to begin with, right? Because the law was just one provision and then one criminal provision and then rules framed under that.
Sure.
Today, we have a full parliament enacted law. But when you look at the data principles, which are primarily of consent, purpose limitation, use, sharing, dissemination, erasure and transfer, etc., I feel that it is actually diluted. So it is, of course, captured, and it has to. If it doesn't meet the Puttaswamy threshold, then it would not stand the test of constitutionality.
Correct.
To some extent it does, but to a large extent it doesn't. I'll just give a simple example.
Sure.
There is a right to be forgotten in I should say now the Act, right? But if you look at the provision, it says that whatever data that you have shared, you can go and modify it, or you can ask for an erasure, you can ask for correction, etc. But then a right to be forgotten is a right we have to be able to exercise irrespective of who shared it online, who shared it with a third party, who shared it with a public entity, right? So these kind of small nuancing, which has been missed, will have to be addressed at some level. I'm just giving one example of many in the Act.
Ma'am, and earlier on, Pranesh was talking, of course, about even the appeal mechanism. I think that's also a change from the 2019 to the 2023, and this current version. I think in between there was a version a few months ago as well. But that one big change seems to be the fact that you don't now go to the High Court, you go to the TD SAT. Now, do you see that as a welcome change, or would that actually speed up the process and eventually, the appeal process to the Supreme Court? How will that work?
I'm really, really deeply concerned about this, because for some reason we have decided that the TD SAT is the path for all appeals. So now you have about 3 or 4 different tribunals and their appeals going to TD SAT. So my concern is, one, that it's an established tribunal, so it's a good thing that it can start functioning immediately. But you're creating a log jam where there was none to begin with, by diverting multiple streams into one, river. And if that river is large enough, good, otherwise it's going to choke. So that's my concern. But the fact that an appeal provision has been included in the Act is definitely a welcome move. I just wanted to, if you can give me just one more minute, I just wanted to add one aspect on the query you put to Pranesh on the use of AI.
Absolutely.
So I feel that's actually a very critical question. Because, we come across many cases predominantly by way of opinions with respect to the use of not just artificial intelligence and processing, but also the use of crawler technologies. Generative AI, you've already mentioned, which effectively also uses a crawler technology. So any law, according to me, for it to be dynamic, should be technology agnostic. So we don't need references to AI, blockchain, cloud, etc. But having already recognized the concerns that the use of these technologies bring in, I would have actually expected a better formulation, particularly of 2 kinds of data. One is data publicly available, and 2, protection of data which is held with government agencies, as Kanishk rightly pointed out. And the third aspect is in terms of the use of crawler technology and in creating alternate products, or creating a database which could actually just be culled out from publicly available data. So today, if you have a driving license, your data can still be accessed without you giving your permission or consent, etc. And that's where the concern really lies. And that's where I wish the law had been a little bit more dynamic in addressing this issue.
Absolutely, ma'am. I think those are very, very valid concerns voiced by you. Pranesh, we were talking about the AI piece earlier, but when we talk about the Data Protection Board, now there's a lot of question marks about this new body. It's supposed to be an independent data protection board, and the minister says it will be digital by design, sort of democratizing the entire process to give access to justice across the country, not just in the big cities. Now, in terms of the independence and impartiality of such a body, do you think that a lot of those concerns have been placated or assuaged, or do you think that there are still valid concerns when it comes to ensuring that sort of unbiased and transparent operations of this particular body?
I think concerns do remain, given that matters about governmental use of data will go to a body that is purely appointed by the government. Those concerns very much do remain. But we still do have the court system, and despite and no law can actually limit fully appeals to courts, because that would be denying courts jurisdiction, and historically courts have not taken kindly to legislations doing that. And the way how in the past we've seen courts, for instance, in 91, in the famous Otto Shankar case, even though an explicit right to privacy is not found in the Indian Constitution, in a case involving freedom of the press, the Supreme Court held that no, that has to be balanced with the right to privacy, which, even though not explicit, is implicitly present. Similarly, the judgment in the Puttaswamy case has laid down certain requirements for how privacy has to be worked out, what kinds of limitations may be put on it, under what circumstances. And so if what the government does go beyond that, then courts can and should take notice. So yes, there is a problem with questions of independence of the board, but I think there are mechanisms in India, if the courts are ready and willing, as it were, to actually address those concerns.
Fair enough, Kanishk. Largely, what I do understand is while we can critically analyze the different provisions of this particular law, but it's good to see such conversations are happening. And even when you hear such terms from the government, it's quite refreshing, covering this for the past decade, to see that the minister is talking about the principle of legality, of purpose limitation, data minimization, data accuracy, storage limitation, and accountability. If all of these things, and like Ms. Nappinai was saying, that all of these do stand the test of constitutionality, they're not ultra vires of the Constitution, I think largely, Kanishk, it's a positive move, for the generations to come, and if we look into the future a little bit, if people are concerned about their privacy, there is some semblance of safeguards in place.
Absolutely. We have been debating this for the past 6 years. We needed a law. We can always argue there could be a better way of doing it, but just avoiding that situation of having a personal data protection bill was not the right step. Countries like Pakistan, they came out with their own data protection bill before India came out, right? So we need to be much ahead as leaders of G20. If we're trying to build this out, then we need to set up precedents of doing more. Now, this bill was necessary for the Digital India Act to follow. And, Nappinai can add that this now creates more room for government to do more specifically on aspects on emerging technology, be it artificial intelligence, be it machine learning, be it robotics, the kind of platforms that are being used for collating data, what kind of algorithms that are getting applied, right? So our regulations so far have just been focused on the big tech, right? We had the intermediary guidelines coming in, but there are so many organizations which are collating data and they never seek consent from users. They get breached. They don't even notify the user, forget even going to the government and telling them, you've got breached. So there is a baseline that has been set in place. And we can build on this further with the Digital India Act. Aayush, on that question of the independence of the board and the chairperson.
Yes.
See, if you look at the data protection bill, the government just can't remove the chairperson of the board. There will be a proper process. There'll be hearing, and even the members of the board, they have to work independently. So whenever a new law comes in, it is principally created in a way that government becomes more powerful. But saying that no government will bring in any kind of law which makes them less powerful, that doesn't happen anywhere, right? So saying that, okay, this is not independent, I don't think so. That's the right way of looking at it. You should let the board get formed, let the representative come in. Who are these people? and then let them function, then take that call. All of these aspects could be discussed later, but calling that, okay, this is not independent, or this aspect would not take care of the freedom of expression, that's primarily not the right way to.
Fair enough. Fair enough, Kanishk. I think just on a closing note, Ms. Nappinai, would you like to mention any particular aspects like you did earlier on? But would you like to talk about anything in the process that has been followed? The fact that this really did go through so smoothly, not enough discussions and deliberations, perhaps. Some of these points could have been raised. You raised very pertinent points in one of the articles that you penned recently, that balance is needed in terms of, between rights and duties, and ensuring that privacy of an individual is ensured, and also then that there are proper enforcement mechanisms in place, Ms. Nappinai.
Thank you for that question. Yes, I really always believe that for any law to work, it has to have that balance. If you look at the global data protection laws, the two principles which drive it are: one, user protection, and two, enabling businesses. So these are the two stated objectives for the Data Protection Bill of India also. Having said that, so when you want to balance this, you have to ensure that you're not just paying lip service to privacy. The corporates are strong enough to be able to protect their rights or to contest for against any violation. But to expect the same level of rigor from an individual may be stretching it too far. So we should make sure that the Act itself protects the right of the individuals, gives them easy opportunities for availing remedies, and that it is going to be an effective form of availing these remedies. So when you ask me about any other things I would want to red flag, and why therefore the Parliament should have taken a bit of time to debate, is unlike many acts which may not impact us as individuals, every single parliamentarian in either house is going to be impacted by this law. So if not for the sake of the nation, for their own sake, they needed to pause and debate therefore. So if you look at the way the law functions, if you look at the kind of exemptions and the waiving away of some of our rights that have been built into the Act, I would say that if they understood the implications of it, I'm sure they would have definitely paused before they put up their eyes. So whereas a lot of issues you will already hear about how the RTI in terms of sharing of personal data has been diluted. I find that dichotomy to be very strange, because on one hand, the Data Protection Act only applies to digital data. Every single debate is missing this aspect. So you're going to have a differential treatment because your information is in digitized or physical form. Absolutely. How is that going to be sustainable? Right. So this is just one of the issues I'm raising. You now have an exemption for law enforcement, and rightly so. But it also covers prevention and protection. So what exactly will prevention add? You mentioned about artificial intelligence already. So law is very clear that your data, for instance, if your fingerprints are being collected, it has to be through due process through a parliament enacted law. Now you have submitted your fingerprints for the purpose of a governance purpose, let's say, right? For Aadhaar, of course, you submitted your biometrics.
Right.
And UIDAI has made a statement saying the biometrics are not available for criminal enforcement.
Right.
Today, if the DIA is allowing for preventive and protective measures, does it mean that AI will have access to data collected for a governance mechanism for a criminal purpose? And no person can be put under surveillance without reasonable doubt and without following due process. So these are all a lot of concerns that arise. One, if it had gone to debate, it would have been better, but the Act would have been delayed. So we are actually in this dilemma where, damned if it did, damned if it didn't. So having, the privilege of hindsight in terms of saying, okay, now it's passed, let's see how best it can be evaluated and how quickly also.
Well, if you thought this is the end of Tech Today, then all I can say is picture abhi baki hai. Of course, you can tune into more from this conversation on the Tech Today website and across our social media platforms. Let us know what you thought of this conversation. But like I said, there's so much more on this action-packed episode of Tech Today, but it's from the Tech Today studios and on the other side of a commercial break.
If you like the video, do like, comment, share and subscribe.